Well, welcome to our Facebook and YouTube Live. We're from Reddy and Neumann PC in Houston, Texas. We're going to be talking about F1 students and selecting universities that we have a good idea are maintaining compliance with all of the F1 regulations so that you can feel good knowing that you've selected a good school to attend. We're also going to be giving you updates on the H-1B CAP season that's coming up starting in April of this year, talking about premium processing, H4 EAD, latest information that we have about backlogs and processing times, and of course answering all of your questions that you have live for us.
Emily, are we going to discuss about what are the best schools? Or are we going to try to discuss about what are the things that they need to look that they find the schools to be in bad position? There are different rules that are applicable to the US people who are going to schools, and there are different rules that are applicable to the students who are coming from foreign countries. So we're going to only address the issues that the foreign students should be very careful about when they are picking into the universities. Emily, what are your ideas, as we know that we have this big issue of University of Farmington. There are a lot of other universities that not a lot, I would say, there are some universities that we don't feel comfortable. So what are the tips that you want to give it to them?
Yeah, so I think a lot of people get confused for F1 students when the government has approved certain schools to be able to take in international students and issue F1 visas. Shouldn't that government approval mean that it's a good school? We're talking about the SCVP certification, or allowing a school to log in and use the SEVIS system. For a school to be able to do that, they have to first be approved by the government. That's just your baseline. Any school that is going to be issuing an F1 visa, that's the minimum standard they have to meet. That doesn't necessarily mean that it's a good school to attend. How many universities and colleges currently have certification and have been approved by the government to grant F1 visas?
8,744 institutions were been given permission by the government to issue the student visa, the I-20s for the things. This is from the government website, 8,744. I was been telling 3,000 roughly figure. I'm way off from the authorized schools that were allowed to give the student visa. It's actually 8,744 education institutes that are given permission to issue the I-20s and get the student visas.
So having that government approval is the base level that you need to start at. If they don't have that approval, you can't get an F1 visa. Going up a step further, look for their accreditation. The university should be an accredited institution. There are different regional accrediting agencies.
Wait, Emily, what do you mean accredited? Are you telling that the government will approve the universities without the accreditation also?
Exactly. So just because the government approved the university does not mean it's an accredited school. You need to check that as kind of your next step. Once you verify that they're an SCVP certified school, check that the school is accredited. From that point, you want to start looking at what are their admissions requirements. How easy or difficult is it to get in? We're finding that there are schools out there that you apply today, you're accepted today. There's, for a master's degree program or a PhD program, there's very little review, there's very little requirements or criteria to be met in order to get in. That might be a sign that maybe this school isn't the best for you if you are planning to study here. I mean, you're paying these schools a lot of money. You're paying all of this tuition, out of state tuition for sure, and you want to make sure you're getting a value out of that. So you don't want to waste your money on a school that is not providing you with a good education. On top of that, you want to look at what their class requirements are. When you enroll in their classes, do you actually have to meet physically with your professors on campus? Are they offering you all these online courses, or are they requiring you to come onto campus every week to take the classes and physically be in class?
Okay, wait. I want to go dissect each of the things. First, are you telling that if the university that is giving admission immediately online and they are starting the classes, online classes online, are they not good schools?
Yeah, I would certainly question those schools for an F1 international student. Now, that being said, there's lots of online schools out there. There's lots of legitimate, reputable schools that are providing online degrees for U.S. citizens and permanent residents. But if you're specifically on an F1 student visa, you have to be very careful that you're complying with the physical class requirement.
And why is that you're telling that for the U.S. people, some of your family members have done an online degree in the distant education. You say that that's good for your family members. Why is it not good for student visa people, Emily?
Well, I mean, the whole reason you're granted this F1 visa is to come here and study. If you can take these classes online, why do you need to come to the U.S. to do that? You could study from your home country and get the same degree. So that really defeats the purpose of the F1 student visa, which is for you to come here and physically study classes at a U.S. institution.
So, Emily, you said another point is that the admission process should be difficult or easy. Which one is better scored, though?
Well, the more difficult, the better in terms of the, reputation of the university.
Do you mean to say that, if I want to apply in Harvard University or Yale University, well, my chances of getting is less? Does it mean that the easier, if I apply, there's a greater chance of getting the application approved? So these smaller universities are not good. Not so world famous universities are not good. Or do you have anything else that you want to express on that?
Yeah, I mean, if your application process does not require you to submit official transcripts from your prior schools that you attended or degree certificates, doesn't require you to take a GRE for graduate school or any of those exams, or there's no TOEFL requirement, that might give you the question in your mind, is this a good school? Do they just let anybody in? And if they're just letting anybody in, maybe you're not getting a very good educational value out of the money you're spending on that school.
So one other issue is that there are some schools, Emily, and these are not, I'm not speaking of the schools that are giving TOEFL or GRE or GMAT, which normally people can attend the classes. Most of them, they start every month, every 2 months, but there are some universities in master's degrees and some doctorate degrees. They are, when you apply them online, they are giving admission on the same day. And the college starts on the same day. Do you suspect anything in that?
Yeah, I just don't understand how that's possible. I mean, a typical U.S. university has a fall semester start, a spring semester start, a summer semester start. Some might do trimesters, some might have a mini-mester in between, but for the most part, there are very specific dates on when your program starts with most U.S. schools. So if the program miraculously starts on the day you happen to submit your application, that is very unusual because, I mean, it takes advanced planning. They have to review your credentials and make sure you qualify to get into the program, for one. How can they do that in just a day? And then you're already registered for classes and attending classes that same day? I just don't see how that's possible. That's not how most U.S. universities operate.
So you doubt those universities where the grade starts for any day?
Mm-hmm.
Okay. Any other tips that you would think that the students who are coming from different parts of the world need to be careful on this universities?
I think that you have to be careful of what people are calling day one CPT schools that are almost advertising to international students that we provide work authorization right away as soon as you join. That is a big question in my mind about whether that school is properly complying with the F-1 regulations. And I also question that where we see a lot of situations where someone is going back to school for their second master's degree, maybe this time around they're getting their MBA, but the CPT that they're being given is to work as a software developer. I'm a little confused as to how an MBA program would find it, immediate participation in working as a software developer is necessary to get your MBA. That's one of the other things that concerns me about these kind of schools.
So there are three main points you said, Emily. One, the admission process should be decent enough.
Rigorous, I would say.
Rigorous enough. The second thing is that class cannot start anytime it wants to, unless there are some institutions that are like GMAT or GRE, the classes can start it most of the time. And also the ones that give the day one CPTs, where they give the work authorization, you doubt them. And you also pointed out that the universities that are not requiring students to physically attend the classes, you say that's a big no-no for the F-1 student visa people to come in. Now, in light of the scenario of University of Farmington, Emily, do you expect some more things like that to happen? I know that we have University of Northern New Jersey and we have University of Farmington. Both of them are sting operations. However, we also noticed that universities that have given, that have the characters, what you pointed out right now. One is the day one CPT, not requiring students to attend the classes, and also those people whose admission process is easier. You said, and of course you said accreditation too. So these 3 points where they have given day one CPT, not requiring students to attend physical classes, and not the admission process is too simple. There are a couple of other universities that got into trouble where people fell out of status. In the case of Tri-Valley University. Then there was another university, which is Silicon Valley University, that got into trouble because of that reason. Now, in those periods of time, we have not seen the immigration authorities arresting the students. They did arrest some of the management of the university, but they did not arrest any of the students, those who are not involved in the management of the university. Now, we are seeing a trend that the first time they started arresting students for going to these kind of universities. So are there any other universities that you think are expected to fall into the same criteria as this University of Farmington?
As far as that they're actually fake universities?
Yeah.
Yeah, I would not be surprised at all, if there are other schools out there that are set up by ICE as sting operations. That would not surprise me one bit.
There are a couple of other indications that we have noticed is that these universities are advertising, Emily, in the media, which is only for immigrants. And in these universities, they are clearly mentioning in the advertisement, the brochure says day one CPT.
Which that term doesn't exist.
Yeah, and they mention that the admission process is they will give the same day admission. So these and surprisingly, when you go to these universities, I was being told that there is no local students; it's all foreign students. That's probably a good indication that people need to be aware of.
Yeah, and I would definitely Google the address of the university and just look at the Google Street View. That kind of can give you an idea of is this a campus or is this just a one office inside a building? There are some that look just like a warehouse on an alley that I've seen where I Googled the address, and interestingly, they're right next door to a USCIS field office. I found that the other day. Yeah. So
we don't want to name the universities. So they are like a warehouse, and they're next to the USCIS office.
Yeah.
Whoops. There might be more in the pipeline, guys. If you are attending any of these schools, we are strictly telling you guys, don't do that. If they don't require you to go to the physical classes, don't do that. After we have released all these videos, we have had a lot of people They check with their universities only. And the universities are telling, no, we are good universities, we are not fake universities. Even if they don't follow the regulations, you will be in trouble. That's the way law is built. If the university is not following the regulations, you are going to fall into trouble. Look, in the University of Farmington, Emily, I have seen the website that day, on the Wednesday, on January 30th. It says it was established in 1952. Their Facebook page, oh my goodness, everything was very good. So if you're not attending the classes, guys, if you're not going weekly classes, it doesn't matter what a website says. It doesn't matter. I mean, that's the way I look into it. Emily, any other stats that you have that you want to give it? One thing is that, as I pointed out, that there are 8,744 institutions that are authorized as of today, according to the immigration website, ICE website, that can issue the student visa. That's called I-20 application. Not the visas, but the permission to get the visas. There are 1.2 million student visa people in United States at this point of time in United States. So it is up to you guys to be aware of what is going on with your university. Don't put the burden on them. If you're not following the regulations, what are required, the minimum, bare minimum, if you're not following those things, you definitely have good chance for trouble.
All right, one of the other issues that I wanted to discuss is a recent report that was put out by the American Immigration Lawyers Association on processing times at USCIS. Their report finds that they're truly reaching critical levels to the point where it's impacting employment-based immigration, it's impacting the businesses, it's clearly impacting the workers. And the data that they found, the processing times, the overall processing times have doubled in just the last few years for all types of applications combined. So at one point, some of their data were showing that back in fiscal year 2014, the average processing time of all types of cases USCIS handles was 4.96 months. Now, fiscal year 2018, it's 9.48. So processing times are out of control right now.
2018 October. Oh yeah, from November onwards to January, Emily, I don't know, it's probably went up higher. More.
Yeah, and in April of last year, the Department of Homeland Security had to report to Congress how many cases were in its backlog at that time. 2.3 million at the end of fiscal year 2017. And they also noted that the way they worded their report made it sound like prior to that, the highest the backlog had ever been was 1.7 million, and that was all the way back in 2004. So the backlog has almost doubled since 2004.
I recalled in 2004, it was Bush, 2004? Yeah, it was Bush. He fired all district directors because of the delay.
So for the 485 processing,
for all the delay process, he fired a lot of officers at that point of time. George Bush has fired all those officers, most of the head level officers, because they didn't cut the time out. And guess what, Emily? In 2005, the time dipped down so much. But this government seems to be that they came with the agenda of wall. It looks like they are putting a wall on the legal immigration, not the illegal immigration. That's the way it looks like, because the way you are sounding is, it's the historical level, because I remember last time when it touched the historical level, George Bush fired all the officers because they're delaying all the applications. And now we are way, way behind than what, and with the new technology.
Right, it should be, there's no reason for that.
So Emily, in the cases where they have the cases where it's an extension, amendment plus extension, when there is a 240-day rule, I mean, you can't work after 240-day rule, and these people don't accept the premium processing, what do they do in those situations, especially?
Yeah, that's a good question. You can submit a service request, try an expedite request, explain that it is a business necessity or emergency situation, financial hardship to the company that's going to be caused if this person has to stop working because they're reaching the 240-day limit. There's not a lot that can be done, unfortunately. The main thing that you can do, that you can control, is to file early. Don't wait until a month before your I-94 is expiring to file. File 6 months in advance, and that buys you extra time on that 240-day situation.
Now we are noticing significant amount of denials. What are the options for them? As you know that if we go to the appeal or motion to reconsider, it seems that our chances are very bleak. Are there any alternatives, and what are the alternatives for it?
Yeah, we're seeing more and more reports that litigation is successful in these kind of cases. Just last week, a company filed a lawsuit for someone whose H-1B extension had been denied after they had gotten 4 previous approvals with the same employer. This person is 1 step away from their green card, and all of a sudden USCIS decides they're not working in a specialty occupation. Well, what were they thinking the last 4 times they approved the H-1B? Obviously, it was a specialty occupation then. So there was a lawsuit filed by this company just a week ago, and the decision has already been reversed. And we're seeing that time and time again, that the government is quickly negotiating and settling these cases, reopening the denials, and issuing approvals as a way to end the litigation. So that may be the new step for U.S. businesses to take when they're facing these denials that are just ridiculous right now.
Andy has this question: does every CPT, a day one again I will repeat again. Andy said, does every CPT has to take some action, or it's only the day one CPT that need to be action? One is that all CPTs have to be under the regulations. They need to be properly authorized by the DSOs. Typically, the universities which are granting CPTs after you complete your 2 semesters, and they're granting CPT in your relevant field, I think so we don't see any trouble with them, have you? Mm-hmm. It is only the universities that are granting the day one CPT that you join in the university that are in trouble accordingly. Now, if you look into the statistics of the amount of H-1Bs that we filed, Emily, and the cases that we filed with the day one CPTs as compared to the people who have worked on CPTs, have you noticed any denials on the people who worked on CPTs that were given after 2 semesters?
No, typically these people went to school for 2 semesters. During the summer, they got an internship and did full-time CPT for 3 months, and then continued their studies after that. No problem in getting the H-1B approval in those situations.
Not a single denial has ever come on those things. However, to the contrary to the point, on the people who have done the day one CPTs, we have had a significant denial in the change of status for those people. Sometimes the immigration approved the H-1B, but they consider that the CPT, the day one CPT, is not a good thing, and they denied the change of status for those applications. And those went significantly higher, starting around June of 2018, they went very significantly higher.
What do you think about a program where you just attend the classes 3 days per semester? Do you think that is considered physically attending classes?
3 days per semester? Is it a seminar?
Right.
I'm sorry, you didn't answer my question. Is it a university or seminar?
University.
Well, when I go to I attend more in my Immigration Lawyers Association. I attend more of it, even though I'm not going to school with my Immigration Lawyers Association. Then what this gentleman is speaking is, it's a semester, three days. That looks like a seminar to me. Definitely does not look to be a university at all. And please make sure that the F-1 students have to take a full coursework. There's no exception for it. The U.S. citizens or the U.S. people who are residents in the United States who are not on F-1 visa, they can take 1 class a semester, it doesn't matter for them. They can take whatever they can skip a couple of semesters. But if you are here on a student visa, you are supposed to take full coursework. And if you are attending 3 days of classes in one semester, that's 6 days per year. I attend more continuing education as a lawyer without going to any school than these people. I don't think so these are good universities at all.
All right, we'll take a couple of questions here. We have a question about the PERM process, and while you're waiting for the prevailing wage determination, can the recruitment, the advertising be done at the same time? And the answer is yes. You can run the advertisements while you're waiting for the prevailing wage, especially right now. Prevailing wage processing times are exceeding 4 months. And so that is an option, but there are some risks, because what happens if the prevailing wage comes back higher than what you anticipated, and now you've just run all of your advertisements? You're pretty much stuck with the description that was put in the advertisements. You either have to start over or file with that higher wage that you may not have expected. And other issues that can come up is because it's taking so long to get the prevailing wage determination, you are limited on the amount of time you have to complete everything else and actually file the petition or the labor certification after the prevailing wage is issued. If there's any problem with the prevailing wage determination where you have to ask for a redetermination, you may not get that back in time to file. Your advertisements might actually expire because the ads are only good for 180 days.
Vamshi asked this question: what is the minimum physical hours that F-1 student visa should attend per semester? Vamshi, it's not per semester that you should address to me. The question should be weekly. How many hours you're supposed to attend? Now, as I said to you, that you're supposed to take the full coursework. Now, it depends on the university. If I'm not mistaken, Emily, full coursework would be approximately anywhere between 12 hours to 15 hours. So you're supposed to spend in the classroom between 12 hours to 15 hours if you are a full-time class student. There are some exceptions that may be there under limited circumstances that might allow the people to attend 9 hours a week. There are some that are there, 9 hours a week, not semester please, not month, but weekly. There are some exceptions available for 9. But my thing is 12 hours. Do you have anything on it?
No, I would agree with that. Kishal has a question about passport validity. So it looks like he's planning on filing an H-1B this year in April of 2019, but his passport is expiring in 2020, but it's too soon to renew the passport. Is it going to cause a problem for filing the H-1B petition? No, no problem at all. As long as the passport is valid at the time you're filing, that's all you need. It's okay if it's going to expire sometime during the validity period that you're requesting. You can still get the approval for the full period of time you're requesting. One issue that can later come up is when you're traveling. If you're entering and you have a passport that's expiring before your I-797 approval notice expires, sometimes the CBP officer will only give you the I-94 that's valid till the date your passport expires. So once you renew your passport, then you either have to travel again to get a new I-94 with the full validity or potentially file an extension. The most important thing is if you're in that situation and you're traveling, your passport's expiring before your I-797 approval notice, make sure to check your online I-94 as soon as you enter so you know exactly when your I-94 expires. I come across so many people where they didn't even think to look at it until they're ready to file their next extension and come to find out their I-94 is already expired and they didn't even know it. And so that can lead to an issue of unlawful presence, which we definitely want to avoid, and it can create issues later. So make sure that you check the end date that you're given on the I-94 if you're traveling in that situation.
San Idi he doesn't have a question, he wants to ask the opinion on whether or not premium processing is going to be reinstalled on February 19, 2019.
I'm cautiously optimistic. I've been asked that question at least 10 times a day for the last couple of weeks here. I would say with the exception of last fall, USCIS is generally held to their word when they said it was going to be back by a certain date. And they've already brought it back for the CAP cases finally earlier before February 19th. So I think that gives us some hope that it should be back. I'm cautiously optimistic.
Divya has this question. She's in day 1 CPT college. She wants to move to the H4. The better option is change of status or going and getting the stamping. I would recommend to go and get the stamping right now, because the change of status will take a long time for you to get it. H4 visa in general as compared to are better visas in getting stamping compared to any other visas that I know I bought.
Pankaj has a question about filing an H-1B transfer. Is it always necessary to file the I-539 for H-4 dependents when you're filing the H-1B transfer? The answer is no, it is not mandatory to do that as long as the H-1B holder is maintaining status and the H-4 has not expired. The H-4 remains valid, even though it was originally approved with a different employer. The problem that comes in is when you file your H-1B transfer, you're likely to get an extension giving you an I-94 validity that's later than your spouse and children, and if you don't pay attention, you might accidentally forget to file the H-4 later. Another problem is if you file them separate, so let's say you file your extension and get your approval, and then a year later it's time to now file the H-4 extension. When you're filing the I-539 by itself, there's no premium processing, and the processing time is ridiculously long right now. It takes forever. So you have a much faster processing time of the I-539 if you can file it along with the H-1 transfer. So no, it's not mandatory, but it is a good practice to file them together just so everybody has the same end date and faster processing of the H-4 itself.
What are the things that people need to be careful when they're filing for the new quota, Emily? Some people wanted to know what are the tips they need to have it.
Yeah, I think there are several.
Now we forgot, with all the University of Farmington, we forgot that on the same day the regulations are finalized. Can you explain more about that?
Yeah, so we do know this year that the filing process will be the same as last year. The electronic registration system will not be in place for this coming April. They're going to delay it until April 2020. So everything is business as usual. The only thing that the regulation did right now that is taking effect for this year is changing the order that they conduct the lottery, with the intention that more U.S. Masters CAP applicants should be selected if everything goes as what they've planned. Now, as far as tips for filing your H-1B in the CAP, I think the number one thing is choosing the right employer. Your employer should never ask you to pay for your H-1B or pay them for the benefit of filing for you. The employer should be a reputable employer, a legitimate employer. You know, if they have other employees, you should talk to those other employees, especially if they have other employees on H-1B. Make sure that they're satisfied with how the employer supported them through the process when they got their H-1B. The employer should have actual work available for you at the time of filing in April, not speculative employment that they might have in the future. If an employer is telling you, yeah, I'll file your petition for you and I'll find you a project later, you need to run away from that employer. That H-1B is likely to be denied. If it miraculously gets approved, it's probably going to later end up revoked. The employer has to prove at the time of filing that specialty occupation work is available for the full period of time they're requesting. Other things to look for are the occupation code that your petition is being filed under. This will be on your LCA, the labor condition application. There are some occupation codes. You can look up the code that in what's called the Occupational Outlook Handbook. You can Google that, Occupational Outlook Handbook. Once you get to that website, you can enter the code that you're seeing on your LCA, and it'll give you kind of an overview of that occupation, and especially what the education requirements are for that occupation. In the Occupational Outlook Handbook, it should say something like, this position normally requires at least a bachelor's degree in X field to do this job. That's what you want it to say, or bachelor's or higher. If it says that some people have a bachelor's but some people don't, or if it says that any bachelor's will do, you be in any kind of field, or maybe they just list 5 or 10 fields that could qualify for someone for the job, you may have a specialty occupation issue where USCIS says this job does not normally require at least a bachelor's degree in a specific field of study, and therefore it's not a specialty occupation. You could end up with a denial. Also, check the wage level. There's nothing saying that you can't file with a level 1 wage, but if you're going to, for some jobs, you just need to be prepared that that factors into the specialty occupation question, and it also becomes a question if the job duties sound more complicated than the wage level that you're selecting. So the wage level should be consistent with the complexity of the job duties. The higher the wage level, the better generally the chances of approval are. I don't know if you have any other tips.
It's better to act very fast, Emily, rather than going very delayed. So it's same old system. The good thing is that the master's people have 16 to 17% better extra chance this year than compared to the last year, if the same number of applications will be received. A good question came from Ravi Kant, Emily. It's a controversial question too. I don't know if you want to answer it or not. Why is the ICE or USCIS not making any statements on the day 1 CPT?
Yeah, that's a great question, and I get asked that every day as well. I think that the issue is you have 2 government agencies that are interpreting the same regulations. So even though they're both under Homeland Security, ICE is the one that issues the regulations for F-1 students. USCIS is the one that often has to interpret them when they're processing a benefit request, such as an H-1B change of status petition or an I-765 OPT application or STEM extension application. And you know, with oftentimes in government, the right hand doesn't know what the left hand is doing. There's no real coordination between the 2 agencies, even if they're under the Homeland Security umbrella. So I don't know if it's by design that they're purposefully not
I think so.
clarifying on that.
Yeah, my reason is a little bit different than yours, Emily. There are some research institutions that take students, Emily. And these research institutions, I mean, I know some of my friends who are doctorates in biomedical, whatever there is, and they tell me that they sleep in the labs, and every 3 hours they have to mix the things. And that's considered as working, and it's not just class that they are doing. So in limited circumstances, when they are doing high-level research and they need to, and they're going to the classrooms weekly, and as a part of their education, it's essential that they need to do research, either finding all these kind of medicines, all these kind of disease prevention things, those things, and they may need those day 1 CPTs. There are also very limited exceptions where, let's say, a nurse is there and she is going to the college, or maybe second level of nurse, not the first level, the second level of nurse, and she is going to the college. She probably need to touch the patient. She need a work permit. There are very limited exceptions, and those are only if they are going to the regular universities, and the research is most probably is occurring on the premises, Emily, on the premises, especially if it's the first 2 semesters. In the first 2 semesters, if after the first 2 semesters they are giving CPT, that's different. Within the first 2 semesters, there are very limited exceptions there. And those limited exceptions are very important because that's where most of the research happens in United States. Most of the discovery happens in United States. Drug discoveries, plastic, physics, chemistry, there are some things that are there. And that's where these people require day 1 CPT. However, we have seen these universities that don't tell their students you need to attend the classes, go work wherever you want to. That definitely is illegal, but there are very limited circumstances, and if you think you fall into those limited circumstances, I would strongly recommend that you check with your lawyer, not with the education institution. If you fall into that particular exception where the day 1 CPT might be issued in exceptional cases.
Yeah, and I think one other thing to just be aware of is most of the schools Rahul is talking about, where they're a reputable school, it's a research institution, people are doing research, and that might be situations where CPT is authorized earlier. They always have information on their website about who can be eligible for CPT, and it's very restricted. They make it clear that during school, during the semester, 20 hours is the max. I mean, when I was in law school, we were not allowed to work more than 20 hours.
Oh, you're a U.S. citizen.
Right, and I'm a U.S. citizen, so, you know, and, but on top of that, they make it very clear that it's going to be difficult for you to both work and attend classes, therefore your employment should only be local to the university. Yet people on these day one CPTs, they're all across the country and only visit the school
across the country.
Yeah, they're all over the place.
More than 1,000 miles from the university. That definitely. So even though the exception is available, if you take it the way that they are being interpreted by some of the universities, that is very wrong. Don't ask your university and come back to us, please. We're tired of it. It is really same thing. We went to the university, they told you don't have to attend the classes at all. Really? You don't have to attend the classes? We don't consider that as good. Don't take their word, it's up to you. You want to take their word, you do whatever we can't assure you anything, but if you take our word, please don't go into those universities.
All right, another question was updates on the H4 EAD. There's not really been anything going on. Why haven't we heard anything? So we have kind of two processes going on at the same time. We have the court case where the briefs are due soon for the government to explain what they plan on doing with the H4 EAD. And we also have their statements months and months ago that they were in the process of issuing this proposed regulation. I checked it just now. There's still no proposed regulation submitted to the OMB, which tells us that we're not really that close to seeing an actual proposed regulation. So I think everything's just kind of waiting at this moment. Sorry, go ahead.
Ram has this question. Is CPT legal for second masters, day one CPT?
According to USCIS, definitely not. They say that once you've used your OPT at 1 degree level, the only way to get more practical training, whether it's CPT or OPT, is to go up a degree level.
Senora has this question. Can CAP exempt organizations can file premium processing? Yes, they can file premium processing. That's never been suspended.
Question on filing an amendment due to a location change. Once the amendment is filed, do you have to wait for the approval before you can start work at the new location, or can you start as soon as it's filed? And the answer is you can start as soon as it's filed under the matter of SIMEO guidance. You don't have to wait for the approval. It's kind of like filing an H1 transfer where you're authorized to start working for the new employer based on the filing. You don't have to wait for the approval. Same idea. You can start at the new location based on the filing of the amendment.
How do we go to the federal court if the H-1B is denied?
Generally, it would be the employer that files a lawsuit against Department of Homeland Security and the head of that agency under the Administrative Procedures Act, basically arguing that the government's decision was arbitrary and capricious and not reasonable in light of all of the factors involved. So that is something normally that the employer would file.
Another question with Abhiram from the YouTube, same kind of question, they ask differently. He has a question, we have weekly classes online, will that be any problem? No, it's not going to be a problem if you are not on a student visa and you are in your home country, that's not a problem. But if you are on a student visa physically present in this country, the only reason why your body is in this country main reason is to go attend the classes. If you're doing it online, you don't have to have a student visa. The distant education is approved in USA. You can be in your home country. If you have a student visa and you are not going to the classes, you are defeating the purpose for which the student visa has been issued.
I'm just kind of amazed at how many people are saying that they only have to attend physical classes once in a semester or 3 times in a semester. Why are you in the United States on a student visa if you don't have to ever go to class? That's got to be a red flag in your mind. So no, if your school only requires you to go to class 1 day a semester, that is not a good school.
3 days in a semester, not a good school. If it requires you to go 3 days in a week physical, I think so it might be considered to be a good school. It doesn't have to be 4 days. I see some of the schools, they take the subjects, my niece, she only takes subjects only 3 days. She wants to leave 2 days off. My son wants to take 4 days, and some people take 5 days. So it depends. But if it's 3 days also a week, that's fine too, as long as they are spending at least 9 hours to 15 hours, depending on the class.
All right, so we have a situation, someone's friend had their change of status denied specifically due to status violation from day 1 CPT, and he wants to know, has unlawful presence been triggered? The denial doesn't say anything about having to leave the country. And that's a really good point, which is very confusing when you receive such a denial. USCIS, the language on their denials is horrible. It is totally unclear. They may say something like, your status, change of status has been denied due to a violation of status. You are no longer present in lawful status. Well, of course, we always keep talking about unlawful presence, so they don't use the word unlawful presence in these denials. They don't say anything about the 3 or 10-year bar in these denials, but they still are triggered. So when it gets triggered depends on how long this person has been using this CPT that caused the change of status to be denied. If the person started this CPT on or before August 9th when the memo came out and they got the denial today, they've accrued unlawful presence from August 9th till now, and when they leave the country, that is when the 3-year bar will be triggered because they've exceeded 180 days of unlawful presence.
Emily, you've been accused of giving wrong information, Emily. You are telling that they are accruing the unlawful presence, but in the civis system, they are still in there.
Right.
And when they are approaching the university, and the university people are telling you're authorized to work. Now, can you explain whether you are right or the university people are right?
Right. So our understanding of how the civis system works in the event of a denial with a change of status denial that says there was a status violation that occurs, USCIS does not go into the civis system and terminate the student's record because of that. They provide the information in the civis system, and it's up for the school official to review that information and decide whether to terminate the student's record or not. Sometimes USCIS could be wrong. Sometimes the student plans on filing a motion to reopen or a motion to reconsider the change of status denial, and in those situations the DSO might leave that record open. But in general, if it's clear that a violation occurred and the USCIS decision is correct, the DSO should be going in and terminating that record, but they aren't. And then some students are actually transferring schools, no issues. They're traveling, no issues. They're coming back in F-1 status. It doesn't make any sense to me. That being said, the DSO is not the only one that has the capability of terminating a student's record. ICE can do it too, and they have access to the student's information. They have access to know that that change of status was denied. They could go in any time, terminate the record, and put the person further into trouble.
When the ICE does, Emily, when the last time they did terminated the 600 student, they did on 29th July at about 10 p.m. They knocked the doors of the students at 6 a.m. in the morning to lock them up. So even though your civil system says you're safe and your university DSO is saying safe, once the USCIS has denied your change of status because you violated the status, you are in danger of occurring and you should consult a lawyer and take action immediately?
Question about traveling into the U.S. When the visa stamp is expiring within the next 30 days. So the visa stamp itself just has to be valid on the day you're entering. Technically, it could expire the following day, and that's fine. However, if an extension of stay is needed after you're entering, depending on what type of visa you're entering on, this particular person is talking about a dependent, so I'm guessing maybe an H4 dependent is getting ready to come in and their visa is expiring in the next 30 days, it can be helpful to have a letter from the employer of the H-1B holder that confirms that once this person enters, we intend to file their renewal and we'll make sure they don't overstay. That's the biggest issue is USCIS or CBP when you're entering and your visa is expiring soon, they want to make sure that you're not planning to overstay. But it is dependent on the type of visa you're entering on as well.
One of the questions that comes often and then again is that my friend who was on day 1 CPT got his change of status approved, no problem. Any comments on it?
Yeah, I'm hearing that from a lot of people. And just be aware that the change of status may have been approved in error according to USCIS if there were facts that were unknown to them at the time they were adjudicating that change of status. So for example, let's say that you had your 1 year of OPT, and during that 1 year of OPT, you were unemployed for 6 months, and USCIS wasn't aware of that, but they approved your change of status. They could always come back with a notice of intent to revoke if they find out about that later, and all of this information is tracked in the SEVIS system. That's exactly why ICE created the SEVIS system, is so that they could more closely monitor students. So when we're talking about someone who's already received a change of status approval, I think that most likely the August 9th unlawful presence memo probably doesn't apply to you anymore because you're no longer in F1 status. But if a status violation occurred and that change of status was granted in error, you may be found to be continuing to violate your status. So you definitely should discuss with your attorney about the option of exiting the country now, obtaining the H-1B visa stamp and coming back, and what benefits that would have to you in the long run to cure that prior violation.
And just for the YouTube audience who are this question, Emily, is that the University of Farmington students, a lot of them got their H-1B approval from the university. They didn't have any trouble. However, the after the fact is that, of course, the ICE went after them and issued the notice to appear. That's a different issue. But yes, sometimes they do approve the cases and then they come back later to hunt you guys. Anything else, Emily? A lot of questions today.
Yeah, so someone has an RFE right now on an H-1B change of status petition that asks about typical specialty occupation things, and then it's got a section about CPT and maintenance of F1 status. Will that be an issue? I would definitely recommend converting that to consular processing, assuming that your CPT falls into one of the categories we've talked about earlier, because you're at a very high risk for a denial of the change of status. And if you've been doing that CPT since before August 9th, you've already passed 180 days. If you get that denial tomorrow, let's say you get your change of status denied tomorrow, then when you leave to get your H-1B visa stamped because you at least got the petition approved, you're going to be found inadmissible. That means they can't give you the stamp for the next 3 years. So that is definitely something that you need to take very seriously and talk to your attorney about how to respond to that type of RFE.
Sagar has this interesting question that comes is that his cap case is the best thing that you can do. You need to convert into premium processing. There's no reason, there's a misconception that the premium processing does not work properly. That is not right. The chances of your RFE and the chances of your getting the approval is same as regular processing.
Okay, well, it's already 6 o'clock and I have lots of comments that we did not get to. I apologize for that. I may have rambled on a little bit too long today. We will be sure to get through those faster next week on Tuesday, so please join us again. If we didn't get to your question and you would like an answer before Tuesday, you can always join one of our daily conference calls. You can go to rnlawgroup.com and find the schedule for that. It's free. They're every day. You can call in and speak with one of our attorneys to get quick, easy answers to your questions. If you want a more detailed, time-consuming discussion with an attorney, you can set up a consultation with us or any of our attorneys, again, by going to rnlawgroup.com. Thanks for joining us today.
Thank you, guys. How many people watched on Facebook?
Oh, I don't even know. Forget to
400
look.
on YouTube. Thank you so much. Next week I won't be there.
Okay.
Want to get Rebecca?
Yeah.